So, good afternoon, everyone, and welcome to the colloquium of the Haifa Minerva Center for the Rule of Law Under Extreme Conditions. Our seminars already a few years ago are broadcasted live on the internet and also on Facebook. And this is the next stage in which we conduct our seminars online all together. So you can also watch our previous discussions. We decided to have a series of seminars, some of which are actually not connected to the coronavirus, and this is one of them, but maybe Itamar will later connect his paper to the current situation. And some of the seminars that we added are specifically dedicated to discuss the coronavirus. So please follow up our program. At the end of this meeting, we'll also post the program for the next seminars. And it's really a pleasure to host today Dr. Itamar Mann from the law faculty of the University of Haifa and one of the principal investigators of the Minerva Center, who joined us 2 years ago. Itamar is a graduate of Tel Aviv University. He did his master and doctorate at Yale University. He's an expert in international law and political theory, and his latest book in Cambridge University Press deals with the law of the sea and the formation of international law. Today he will talk about a different topic, about the Israeli discourse on displacement of people. Itamar, the floor is yours.
Thank you very much, and especially thanks to the participants who have been able to join in these very difficult days, especially concerning the fact that this is kind of taking us away from our the concerns that I'm sure that we have, all of us, during these days that are, very, very complicated. I'd also like to give specific thanks to Banna, who Eli, I'm sure, will also introduce formally after my talk, but who will respond, who has prepared a response commentary. This talk is based on a paper that is almost done and is scheduled to appear in an issue of Theoretical Inquiries of Law, a symposium issue that Tamar, who's also here with us, Tamar Megiddo, also has a paper in, edited by Yitzhak Ben Badji from Tel Aviv University. And this is the special issue is about historical justice in Israel-Palestine. This paper has been in the making for a number of years. It's part of the two-paper project, whereby the first paper covers an earlier period, an earlier historical period. And this paper, an earlier historical period and the discourse surrounding a population exchange in the interwar period and more or less until 1948 when Israel is established. And this paper starts from the establishment of Israel and moves forward in time. So these were little preliminary remarks about the paper. I'll just jump into the argument now. I'll give a short version of it, and then we can have some discussion. Okay. So as many of you know, the General Assembly of the UN, of the United Nations that was established after the Second World War decided on 29th of November to partition the area of the British Mandate in Palestine and to establish a Jewish state and an Arab state. Not long thereafter, in December, the United Nations General Assembly also decided that the refugees that had been displaced during the War of Independence that broke out after the partition decision came out, these refugees will have to be returned to their places of residence. The language of the decision is refugees wishing to return to their homes and live at peace with their neighbors should be permitted to do so at the earliest practicable date, and that compensation should be paid for the property of those choosing not to return and for loss or damage to property which under principles of international law or equity should be made good by the governments or authorities responsible. This decision to allow refugees from the war to come back into the territory of the now established state was at no point in time do I think, at no point in time did the leaders of the Zionist movement and the leaders in Israel and the new leadership of the state, I think in no point in time did they seriously consider to abide by this decision. So the 29th of November decision was very much celebrated as a kind of establishment of a state with the blessing of international law, and this decision had a very different response. And for many, I think, during the time, the decision contradicted the very basic nature of the new state, which was to be a Jewish state that would realize the self-determination of the Jewish people as understood in terms of a Jewish majority within the territory. And others, of course, saw this idea in more religious terms. But there was a question that was open at the time. What is the legal argument, the international legal argument that can serve as a rebuttal for this General Assembly resolution? Of course, General Assembly resolutions are not binding, but there was a kind of understanding that international law is going in a direction that is not consonant with the interests or self-understanding of the new Jewish state at this time. In the screen before you, you see two interlocutors in this discussion, one very well known, the other less well known, that had an idea that became very influential, but not studied enough within legal circles, at least, in terms of how to approach this problem, how to provide a legal argument that would be responsive to it. And this legal argument had a very close, intimate relationship with the idea that the state will be a state for Jews, a state that will be responsible for saving and rescuing Jews that had suffered persecution in many countries in the world, including European countries and as well as Middle Eastern, Arab, and other countries. So on the left side of the screen is Yitzhak Ben Tzvi, who was president of Israel, and on the right side is Leo Cohen, who I want to focus on a little bit. And Leo Cohen was a lawyer who was originally from Germany, left there as a refugee, studied for a PhD in Ireland, was working on constitutional law, self-determination issues, and in the late 50s and early 60s became an advisor in the Israeli foreign ministry. And he was very excited about an idea that was advanced powerfully by Yitzhak Ben Tzvi, that what happened in 1948 should really be framed not as a displacement of a people, of indigenous people in the land, but as a population transfer, a population exchange, whereby two sides of a conflict, each basically removes the population that is not nationally, that belongs nationally to the other side, to to the other side's territory. This is based on a model that was adopted primarily from the Greek-Turkish population exchange that was earlier, and the first paper focuses on. And they wanted to, and Itzhak Ben Tzvi thought this would be adopted for our area. And Leo Cohen was very excited about this idea and decided to focus much of his work during the early 60s to this idea. And this is very perceptible and becomes clear looking at his personal archive in the Israeli National Archives, and especially at a little pamphlet that he edited with a number of other people in the foreign ministry to explain to the world how Israel had responded to the refugee problem during the Second World War. And Israel is presented in this document as one of the greatest countries in terms of its response because it became home to so many refugees, Jewish refugees that had been displaced during the war. And you see here the picture that I focus on a little bit in the paper of the youth aliyah, east meets west. We see on the right side a child, a young boy, presumably from a European country, next to another boy, presumably from a Middle Eastern country. They unite together, and Israel supports them both and protects them both as refugees that thereby become citizens. And the pamphlet begins with an appropriate quotation to this effect, to the following, that goes in the following way. Do you intend to go about all your lives with the word refugee inscribed on your foreheads? The word refugee connotes dependence and helplessness. The sooner you get rid of it, the better. And this is taken from Nehru, Prime Minister of India. And we see here again the kind of precedent that refers to a different part of the world in which a population exchange occurred, India and Pakistan, thereby allowing self-determination to flower and realize in a way that would protect two different groups. Okay, and in the paper I argue that this kind of image of uniting different refugees from different parts of the world, different Jewish refugees, is a kind of Jewish cosmopolitanism, if you will. But it does also exclude, obviously, other refugees that have a very important link to Israeli history. And really, this happens already in the work of Leo Cohen. I'm going back and forth, but excuse me for this. Who understands that the Jews that are coming in the 60s from Middle Eastern countries will be the exchanged population. They will represent the Jews that were removed from Arab countries, and the Arabs were removed from the Jewish country, and so we have this kind of swap. And so it becomes his project to document very closely not only the number of people that come, but also the properties that they had left over in their countries of origin, as well as the price that it took for Israel to integrate them into the new Israeli society. And so he accumulates in a kind of accountant, in his papers, he has this kind of accountant exercise that he accumulates these numbers and shows what is the final price that Israel had to pay, including the properties that were left abroad, in order to achieve this agreement. And this is compared with the value of the property that had been confiscated from Palestinians with the establishment of the State of Israel under the absentee property law. And this argument, and this is one of the main things that the paper shows, is really adopted, and even though it's not discussed kind of explicitly during the entire history of Israel, it always kind of percolates in the background. And where is that apparent? It's apparent very clearly during the negotiations between Israel and Egypt on the peace agreement Camp David, 1979. And here, a number of documents from the archive become relevant. We see, for example, one quotation from a diplomat named Amiel Najjar. I will read this in Hebrew. I think most of our listeners understand Hebrew. I will then translate. יהודי ערב יכולים לתרום לדפלסטיניזציה של הסכסוך הערבי-ישראלי, שכן תביעותיהם מובנות נגד כל ארצות ערב. אש"ף הוא מכשיר לפלסטיניזציה של הסכסוך ולהנצחתו. In other words, the Jews of Arab origin, the Jews of Middle Eastern countries, can be an instrument of de-Palestinization of the conflict between Israel and its neighbors and the Palestinian people. So it's very explicit that the property claims and the rights that were taken, their rights that were violated when they were indeed displaced from many countries in the Middle East, in laws that confiscated their properties and denationalized them. These are used as an instrument to advance and realize regional geostrategic ends, namely to transform the conflict from a Jewish-Palestinian or Israeli-Palestinian conflict to a regional conflict that can be spread across many nations, and that Israel sees at this point in time as more easier to govern, as easier to manage. And in this agreement, Article 8, in the peace agreement between Egypt and Israel, we have a recognition of refugee rights, and we have the article puts in place a mechanism, a claims committee, a mechanism to determine the claims of the different parties involved. And this is understood at the time as concerning the rights of Jews that were displaced from Egypt. But no one really tries to activate this compensation scheme. No one really activates the Claims Commission. And so this opportunity to compensate Jews from Arab countries is missed. And this is noted by activists not so long thereafter. And it's noted in a particular way, which I think is, which is the central argument of the paper, namely that the way that these refugee histories were entangled together, Palestinian and Mizrahi refugees, and also Ashkenazi displacement and refugees, created a stratified Israeli society. And so on the one hand, we see people who are not being compensated, Mizrahi Jews and Palestinians, for their displacement in 1948. And at the same time, under the Luxembourg Treaty, under the treaty between Israel and Germany, Jews from Germany and other European countries are being compensated for, of course, other wrongs that were perpetrated by the Nazis during the Second World War. And in this picture, you see Yechezkel Haddad, who is a physician, a doctor, but also an activist. And in 1983, he writes the book that you see on the right side of the screen. And one of the arguments that he makes there, this is a book about the Jews of Arab and Muslim countries. One of the arguments that he makes there is that really the lack of compensation for the Mizrahi Jews while compensating the Ashkenazi Jews creates a stratification between these two Jewish groups. And this is partly, I think, resonant in terms of why many of these people, I'll start again, this last sentence. Menachem Begin, of course, is famously the opposition to the Luxembourg Agreement that was signed in 1951. And later on, sociologically, Mizrahi Jews became, of course, more supportive of the Likud. And I think this kind of material stratification and the inequality, the inequality, between the way the different, very tragic but very different histories, of course, are treated is part of the explanation for this. Okay, and so during the 1970s and 80s, there are many conversations about this issue that I cannot go to in great detail and that I kind of also skip in the paper. But I'd like to just point to a few more moments before opening this conversation. So Mizrahi activists have often raised the issue that the rights of refugees were recognized during the Oslo Accords by President Clinton, for example, and thereafter no compensation was granted in the peace treaties with Jordan and with the Palestinians. I don't know if it's, I don't think it was appropriate within those treaties to do anything with it, but the existing reasoning continues to be that we're saving these claims for later, for the Mizrahi claims are saved for a later date when there will be an agreement, a regional peace agreement with many, many countries. And so in 2010, we have a law, a statute from the Knesset that once again makes this link very explicit. When we will have a peace treaty with Arab countries and Iran, we have to compensate Jews from these countries. And the argument here is, of course, that this is an instrument of deferring these claims almost endlessly down history and kind of not responding to them in a moment when Israel can, in fact, already respond to them. We see this growing during the former decade. This is a foreign ministry campaign from 2012, I Am a Refugee, to raise awareness to Jewish refugees from Arab countries. And it's explicitly linked to trying to argue against any recognition of Palestinian refugees. This is from a Haredi website. It's a picture of the Farhud massacre that occurred in Iraq, where hundreds of Jews were killed by Iraqis. And the reason I bring it here is that we see that it really reflects even further how the imagination in this time tries to construct the refugees and the migration from Arab countries as part of the same story as the displacement of Ashkenazi Jews. We see on the left side this yellow Star of David, and in a procedure that started in Haifa District Court and then moved to the Supreme Court in Israel, really victims of the Farhud tried to gain compensation under the Luxembourg Treaty, under the treaty with Germany, arguing that the Iraqi actions against them were basically determined and directed from Nazi Germany during the 40s, and trying to impose state responsibility on Germany for this issue. And it really reflects the way that this is all kind of conflated into one history. And during this time, the story continues. I'm going to run a little bit through my screens now because I want to get to a few other points. But what is important here is, and this is a little text by Naam Makati, who is an activist in this area, is that during all this period, this linkage, this entanglement of histories continues in a very, very powerful way. And it's really a strategic move to recognize a certain kind of displacement in order to move from the table a different displacement, the displacement of the Palestinians, that remains a kind of threat for Israel. Now, the paper also deals with the way that this has influenced Palestinian Arabs in Israel, Palestinian citizens of Israel. And here I go back to work by our colleague, Sandy Keidal, who has found in his archival documents the link between the population exchange between India and Pakistan and the expropriation of land in India and in Pakistan, and the expropriation in Palestine and Israel, and so the population exchange model is very, very strong here too, and I also discuss further documentary evidence that shows that for a long time, the Palestinian citizens of Israel, the Arab citizens of Israel, were understood as a kind of exchangeable remainder. The idea was that there was a population exchange that was not fully concluded, and we need to conclude the work that we have already started. And so I'm not the first one to expose this, but there were discussions between the Israeli Foreign Ministry and King Idris Sanusi of Libya, who was in a monarchy there before Gaddafi, to try to conclude another swap by which Jews from Libya will be sent to Israel, and Arab Palestinians from Israel will be sent to Libya. This did not succeed, of course, but it was related to kind of British imperial diplomacy in the kind of backstage. And there were similar talks also with the King of Iraq. And when we talk about the effect on the Palestinian Arabs, we need to think of this also, on the one hand, as part of an idea of population exchange that was recognized in international law during the interwar period, no longer so, but has this kind of legal seed to it. And on the other hand, it's also part of a tradition that was really explicitly called, and still exists, of course, in the right, that explicitly calls for simply unilateral and violent transfer, and has some euphemistic relations to the legal frameworks, the relevant historical legal frameworks. And here we see the Chavam Ze'evi, Gandhi, who is, of course, the person most recognized with this. But this idea of an exchangeable remainder has a different valence as we move to the 2000s. Now we're talking no longer about kind of forcibly moving populations in order to gain other populations instead, but the new version is about a kind of land swap by which certain people, Palestinians in Israel, will be denationalized. And of course, we have one major iteration of that idea following the October 2000 events, and both Ehud Barak and Avigdor Lieberman are advancing different versions of this. And of course, and this is not yet specified in the paper for those of you who had the chance to look at it, the Trump program is also the heir of the same tradition. The Trump peace program is in as much as one can really talk about a Trump peace program. And here, the relevant provision: the state of Israel will retain sovereignty over territorial waters. Sorry, this is not, I'm looking at the second one. Land swaps provided by the state of Israel could include both populated and unpopulated area. The triangle communities consist of Farkara, Ara. Okay, and so I'm not going to read this entire thing, but the idea is that really people can be denationalized within an idea of self-determination that has this underlying premise that a nation the nation and the citizenry should be homogeneous and should reflect one group, which is, of course, not a necessary idea in terms of the history of nationalism, the history of liberalism, or this history of social contract theory. So just to sum up this second part about the Palestinians, the Palestinian citizens of Israel, they were constructed, as I say, as an exchangeable remainder, and of course suffered enormous economic loss by the absentee law and further expropriations of land that continued for many, many years as part of the same paradigm that was running through Israeli, the way that Israel constructed law and politics together. And so the paper ends with a little bit of a normative or prescriptive idea of how to deal with this history. And the title here reflects the main idea to disentangle the histories of displacement and treat them separately according to their separate kinds of claims. Now, this is, of course, very far and very difficult, far from our current political reality, very difficult politically to advance. But I still think it's worthwhile to think of this, and I think it's still worthwhile to advance such a program. And in terms of the very preliminary program that I offer in the paper, the basic idea is to compensate the Palestinian citizens of Israel for their historical damages in the form of reparations, and to compensate Mizrahis for damages not inflicted by the State of Israel, whereby the State of Israel will become the holder of the claim, and it will be able to seek indemnification for those damages from other countries, such as Egypt, such as Iraq, perhaps, countries with which Israel has a very different relationship today than it used from what it used to have, and where such claims can be part of a diplomatic negotiation and a very thick set of relationships that is ongoing. And so the basic idea is that public funds should be transferred to groups that were harmed not by Israel, whereby Israel, the government, will now carry the claims further as a kind of insurer, if you will. And this, of course, raises the question, what happens? I mean, it raises a host of questions that we can talk about, a series of different problems. But one of the major problems is, I think, what happens to all the Palestinians that are not citizens of Israel and that are, in a way, really the larger part of the refugees that have claims against Israel. And here, the paper really distinguishes between those who are citizens and those who are not citizens, kind of leaving open the idea that for those who are not citizens, the negotiation can still remain on the diplomatic level, perhaps with a Palestinian national representative and not with Arab states, because they're instrumentalized the claim as well. And so in that way, I hope to disentangle the various histories, try to advance a program for reparations that will also, in the bottom line, effectuate a distributional change within the citizenry of Israel and advance greater economic justice and greater equality for groups that have historically been wronged.
Thank you very much, Itamar. It was a fascinating talk, and we'll open it for questions to all participants in a second. But we first have official respondents, and I'm very happy to welcome Banna Shoughry-Badarne, who's a graduate of the Hebrew University, and currently is doing a PhD at the Hebrew University and our sister center, the Minerva Center for Human Rights Under Stress. And Banna is also very active in our clinical program at the University of Haifa. Banna, the floor is yours, please.
Well, I used to be the clinical director of the International Human Rights Law Clinic in Hebrew University. Haven't had the chance to be involved yet in Haifa Clinic, but I have great friends there. And actually, my involvement with your clinical program is that my PhD dissertation is about Palestinian women's cause lawyering in the Jewish state, and part of the wonderful Palestinian women lawyers work at your clinic. Thank you very much for inviting me to read this paper and react to it, and I really find it fascinating to track how one lawyer actually could change how we can change history. And can change how do we articulate rights. And in this sense, I think that Cohen made interesting job turning colonizers into refugees. And it's fascinating, although I totally disagree, and I think it's really a harmful way this is exactly what I think how law shouldn't be used. A lawyer should have enough social responsibility to see all parties to the conflict, and not only the party that you represent, and in his case, the Israeli government. And Dr. Mann's article is really important piece of work, of research, not only legal, but also historical work on that makes it really very easy to go through 3 histories of displacement and see how all of these 3 displacement histories were tied together in a way that makes it makes the ultimate victims suffer the most. And in this sense, I think it's really important to follow, first of all, to know the facts, and to see how the tying the claims that Jews from the Arab world have against their own previous governments, and they have, how it was used to sacrifice the rights of Palestinian refugees, both those who remained in Israel and the mass who are not. In this sense, I think that it's really interesting to see the solution that Itamar suggests from a much broader point of view of all Palestinian refugees. Because what you suggest, Itamar, and I really think it's really, I mean, the first part of it is that you said that it's a suggestion for compensation about wrongs that were not done by the State of Israel. And the wrongs against Palestinians were done by the State of Israel and the Zionist movement. Therefore, untying or disentangling the histories of displacement of Jews from the Arab world and of Palestinians is really important. However, the question is, when you suggest reparations and compensations, who pays the price of these reparations and compensations? So for the side of from the side of the Mizrahi, this might be really important, and I think it should be advanced that the State of Israel that invited them to join the collective, the Jewish collective, the Zionist collective, and become part of. Not only become part of the state, but actually the kibbutz galuyot wouldn't be, the whole idea of the State of Israel wouldn't be fulfilled without bringing Jews from all over the world. And in a way, I think that one way of looking at it is that Israel is welcoming them as refugees. Another way of looking at it is actually Israel is inviting them to be the colonizers. So any wrongs that are done, and there are many, I mean, we're not here to suggest that there's no discrimination or a subordination of Mizrahi Jews in Israel. There is, and they suffer a lot, and they are entitled to reparations because of that. But when the compensations are being paid from the property of Palestinians, then for Palestinians, not only that this solution isn't appropriate, but it also makes more harm, because the minute that you justify compensating Mizrahi Jews for the harms that were done by the Arab countries by paying property of the Palestinians, then will the Palestinians, how will they even get back to demanding their individual rights? I think the real issue here is more of group rights versus individual rights. To say that Mizrahis should be, Mizrahis displacement history should be untied from that of Palestinians, it's very important. But I think that as long as the legal rights are not individual rights, but rather are designed as group rights, we will get back to the same problem we are trying to run away from it. And one more very important issue is that this whole monetary compensation project may be very important for a step towards more equality in Israel and less tension between different types of citizens, but it will not solve the main problem that you amazingly explain, which is how this whole idea of population exchange made it possible to see Palestinian citizens of Israel as not only demographic and security risks, but as a remainder that can at any minute be stripped from their rights. And when you talk about compensations for the group, and without tackling the origins of the problem and the origins and tackling the fact that in fact it's not that the state of Israel should compensate for wrongs of others, but rather both both for Palestinians and Mizrahi with different layers of responsibility. These are Israel's wrongs. And therefore, I think that while I totally agree, and I really loved reading this article, I totally agree with disentangling the displacement histories. I think that adding the Palestinians to this to the same kind of solution, instead of asking for historic justice, or first of all giving them back what was confiscated wrongfully, and giving them back the individual rights, those who live here, and then only after we tackle the wrongs done by Israel, we can consider, okay, from what remained, who will be compensated.
Thank you very much, Banna. Itamar, do you want to respond?
Yeah, everyone, yeah. So I guess the major point of contention, as I understand it, between Banna's insightful comments and myself, and I also have to say, towards the end of the paper, I flagged this objection. I recognize this as an objection to my argument, and I think that it's an important objection. I think the main point of contention, however, is a kind of order by which politics should progress in this place. I think that we agree, Banna and myself, and maybe I'm, correct me if I'm wrong, but we agree that a more egalitarian citizenship should be established here, one that does not make distinctions based on ethnic background or religion. My view, however, is that first we need to work for that, and only later can we really try to tackle the wrongs against the entire Palestinian people. We need to start from a position of equality, equality between citizens, which we do not have today. And later, we can also compensate on an individual basis Palestinians from other countries that are refugees. And here Banna says, but this is a direct harm done by Israel. And here I agree to some extent, but I also think there's an issue of contributing harm done by Arab countries that has made their situation even worse over the years and is not entirely Israel's responsibility. And but Israel's first responsibility should be towards its citizens and towards equality between them. And of course, we have another problem of Palestinians under direct Israeli control in the West Bank and perhaps under some Israeli control in Gaza. And with them, this issue becomes even more nebulous. But let's just compare for now Israeli citizens to Palestinians in Lebanese, Syrian, Jordanian refugee camps or abroad in other countries. In these cases, I think that it should be clear that the obligation is first towards citizens. And only after establishing equality can we open individual claims that might be just claims to a fair procedure that will also take into account the way that Arab countries have instrumentalized and exploited these claims over years to make them even worse.
I mean, I agree until now with everything you said. I mean, the only observation I have is that you compensate from what is legally and just legally yours, and what is justified as your property. If someone comes to my house and then brings someone else to my house, and then something really happened, he can't take my property to compensate for his wrongs. So the thing is not if it's true that the state of Israel is first of all and foremost responsible for equal citizenship for all its citizens, but if you have two roots for this equal citizenship. One is distributional justice, and the other is political. With the political, it's really a huge issue, because if self-determination is only and solely for Jews in Israel, then this means that the Palestinian citizens of Israel will always be the remains that in any minute can get rid of. So this is one. And second, with the distributive justice, you distribute what you legally are justified to hold, not what you took from others.
Okay, I just want to say very quickly, and I then open to questions that I understand. I think that on the self-determination issue, I think I made myself clear that I'm opposed to a self-determination issue that doesn't include everyone on an equal basis. And on the just title issue that you raise, I think I'm less hopeful than you that law has such a determinate answer to these questions. And I think that if we just take a positive legal point of view, it might be the case that the answer we reach on many issues is not necessarily consonant with the one that you would expect. Anyways, I don't want to have the last word, and I think that we need to discuss with others. And thank you, Banna, again, for the very, very generous and thoughtful comments.
So thank you, Banna, and thank you for Itamar for clarifying this issue. Let me try to sum up your argument, because your article is very rich and basically deals with two levels of analysis and two issues. The two levels of analysis is the historical story, right? The narrative that you present, which is very innovative, and based on it, some normative proposals, which I subscribe to, by the way. The two issues that are dealt with are first, the issue of compensation that now was discussed between you and Banna, and the issue of the right of return. And of course, they are connected, because if there is no right of return, maybe the issue of compensation should be viewed differently. And I want to ask you about the right of return, because I think your presentation, especially your narrative, is developed on the assumption that there is an international law right of return, and that it's basically followed by most nations. And of course, if we're talking about this period of post-Second World War, you gave the example of India and Pakistan, but there were huge displacements of population in Europe after the Second World War, and without any development of a claim to a right of return. And I want to ask you about this comparative perspective, also from the perspective of compensation to those people who were displaced. And I think this background of whether there is such a right and it is followed, and what happens if it is violated, compensation or not, is crucial both to the narrative and, of course, to the normative section of your paper.
Yeah, thanks for pushing me on that. As a pure analysis of positive law here, and not as a claim of justice, not as a political aspiration, but as a pure analysis of positive law, I do not think the right of return was a binding legal concept in a date that the UN Resolution 194 was declared. So in that regard, I actually agree with you, and I don't think, and I disagree with others that have written that under customary international law, this was already a solid obligation at that time. I think those arguments made by other scholars are more aspirational. They represent the wishes and hopes, the political wishes and hopes of those people, rather than necessarily a count of positive law. However, I do think that from the point of view of justice, there is a strong claim to be made here. But I think for me, it's very important to ask the question, who is the subject that should make a determination on that claim? And I think the subject has to be the Israeli people, the Israeli citizens. It cannot come from anywhere else. It doesn't come from international institutions, and it should be a political idea that is solidified within a political decision that can take place in the form of statute or some other form. And I think that to reach the point where it can be thought of from the perspective of justice and accepted through a difference in immigration policies, basically it would create a different immigration law in Israel. The starting point needs to be basic fundamental equality between the citizens. And so it is a precondition, once again going to my former answer to Banna, it is a precondition to establish equal citizenship, and then we can think of how to change our immigration laws in a way that would reflect historical justice towards the Palestinians as well. I think it's not, and here the details would matter. And the details would not only be historical, they would also be economic, they would also be cultural, and they would have to do with what this equal polity that is not yet existing will want to decide upon.
So you actually talk about the law of return more specifically, and you don't accept Chaim Gantz's argument justifying the only inequality that is justified in Israel is the law of return.
I don't think it reflects inequality. I do think it reflects inequality. I don't think it's justified entirely, in as much as the Palestinian issue is ignored. But I do think that the details are not to be determined at this point. So the methodological kind of silence around this is intentional because I don't think that we have reached the point that we can discuss this seriously or in very great detail. It could be a change in the law of return. It could be an addition to the law of return. It could be a different framework altogether, but these are really, really far out questions.
Let's open the floor for other questioners.
Is it possible to ask something?
Sure.
Distributive justice, because this is actually the basic, let's say, the basis for equal citizenship, as that you lay. Can't we achieve distributive justice without going through all this disentangling of the displacement histories?
I'm sorry, I didn't hear. Were you saying distributive justice or historical justice?
Can we reach this distributive justice without even discussing historical justice and disentangling of the displacements?
I think that's a very serious question, and I think that there are weighty considerations to say that actually the best way to reach distributive justice is to ignore historical factors and to simply transfer funds, money, from the rich to the poor, with ignoring ethnicity, race, religion, all of these things. And that is a position that, of course, exists. It's not my position, and I do think that it needs to be tied to this issue of identity and history. And I think that one can compare it, of course, to the debate in the United States surrounding reparations for slavery. And so in that debate, certain representatives of the Black community, Ta-Nehisi Coates is famous for this, of course, have made the argument for reparations based on historical wrongs. And others have argued that this would basically ignore a lot of people who need a distributive justice claims. I'm more on the side that thinks that identity and distributive justice should be interlinked, but I recognize that there is another program as well that is a serious one. I see that Amnon has his hand up in the.
Yes.
I don't know if I should be the one kind of taking questions, but I just see this for a while now, so I'll just Amnon.
Thank you. This was really interesting. It brings me back to the days I used to do research in public international law, and just two rejoinders to the previous comments and then a couple of questions. So with respect to Banna's, I want to say something with respect to Banna's last question and then Eli's comments, and then try to push you on some fronts about this notion of disentanglement. So with respect to distributive justice, there is a middle position in between just ignoring ethnicity, just being colorblind in that sense, and just looking into social and economic equalities and distributing from there, and the position of having to do historical justice first, and then, and that the position is that you do recognize the saliency of some group identities, but you don't fully resolve the corrective element of who did what to whom, which is part of Banna's point, which I later touch upon. And you say, regardless of who did what to whom, which is an issue of blame and therefore responsibility and therefore corrective justice, as things stand now, there is a duty to distribute resources in a way that takes equality seriously, and it ties to your notion of first making sure that people equal citizens. So I've heard a really interesting lecture by a young Arab diplomat whose family was exiled from Israel, and then some people asked him, how can you serve the Israeli government when your family was basically wronged in such a clear way? And he basically responded by saying, I care about the Palestinian people. I want to first look forward to make sure that, first of all, we look forward to distribute resources equally with justice in equality, distributive justice in mind, and then only then we will be in a position to talk about the past and resolve our differences about who did what to whom. So that's just one comment on this debate. The comment on Eli's point with respect to the right of return, I think I think what you're doing is when you disentangle, you also disentangle the money from the right of return. So this is a form of disentanglement that is a bit peculiar analytically, because in part it requires an analytical structure that is currently not in the paper as it stands, and maybe that's fine. Maybe a future paper can do that, and it ties to this notion also of individual versus group and other rights that are involved. But you definitely disentangle the right to compensation from the right to return, although they both stem from the same moral source. Now, there are ways to deal with this. One way to deal with this is the way to suggest that as an individual right, you have both a right to compensation and a right of return. As a group, you have a right of return only to your state, to the extent the self-determination matters. And then you tie back the notion that when you exercise the right of return to a state that is not your state, that is, when we tell Jews, no, you cannot return to Iraq, you should return to the state of Israel because you were invited by the state of Israel, because you're part of the Zionist program or something like that, then there is a certain wrong that occurs and you deserve compensation for that, but it doesn't follow that you should necessarily have a right to return to Iraq for Jews or a right to return to the state of Israel for all exiled Palestinians. But that's a different, and there are problems with the articulation I just articulated, but that's a different project, I think, but one that you cannot completely ignore if you care about disentangling, because what you do is you disentangle something that maybe shouldn't be disentangled. There is a legal solution for that, of course, and one legal solution, again, is to look to distributive justice and then say that under the laws of immigration, not the law of return, but the laws of immigration, there's no reason why Israel should say Jews get, so Jews get the law of return, but why should the ordinary immigration law be exercised in such a manner that basically doesn't allow Arabs any immigration resource at all? So at the very least, you can say, well, if Arabs are, 20% of the population, at least 20% of the immigration resources, that is visas for Arabs, whether return or not return, doesn't matter whether they belong to refugees or don't belong, we don't care about that. It's just forward-looking distributive justice. But that's, again, something that I think has to be somehow tied into the debate. What I do want to push you forward on, and again, briefly, you seem to blame Cohen a lot, Leo Cohen, and so one would think if only Cohen didn't exist, or putting it conversely, if only Leo Cohen actually was successful in the main project he was involved with, and that is writing a constitution for Israel, because he was the author of the most important draft for the Israeli constitution. So if only he was successful there, then maybe he wouldn't care so much about this other project, because he would have felt that he did what he had to do, and then we wouldn't have had this entanglement. Now, of course, this is not what you're saying, but I think there's a danger that you will be understood as if this is what you're saying, because I think that there are some fundamental, and Sandy writes about this, there's some fundamental, more system-wide notion that these histories are entangled. That doesn't mean that the justice claim should accept this, even though that as a matter of fact they are entangled. Doesn't mean that justice-wise we should respect this. And here I actually accept a lot of what your normative recommendations are, but I don't think that you have to disentangle histories. I think that you can leave histories as entangled as they are. In fact, you can say, look, they're very entangled, but it's not necessarily a devious way of lawyers to entangle histories in order to get some sort of ill-gained or illicit gains. No, you can say, look, the histories are entangled, but there are justice claims, because once there is a state established, then the state owes a duty to its citizens, whether the histories are entangled or not entangled. Point number one. Point number two, Banna touched upon this, I think, in a way. Another thing you disentangle is you disentangle the Palestinian people, because by placing everything on citizenship, you say, well, let's disentangle the Palestinian people for the time being by ordering first equality to Palestinians who are citizens of the State of Israel, and then Palestinians in the occupied territories, nebulous, and then maybe those in the diaspora, because, and I agree with you here on the merits, they were also wronged by others. But I'm not sure, again, that you need to disentangle the Palestinian people in order to do that. Again, I think that you can say justice demands that, because of the notion of citizenry, and precisely because the narrative are entangled, that Israel should recognize a duty to compensate. I agree with Banna that the pot should be made more clear. That is, that to the extent that part of the resources used to compensate Mizrahi Jews are the resources taken from Palestinians, then we have a conflicting source of justice. And I think that then here we should be explicit about it, saying to Palestinian citizens of Israel, okay, you have a right for compensation over your land, and that comes, then your land, we owe you compensation for that particular land, and then we have to first of all give you the land if we can, and if we cannot, then we should give you something in exchange, and that should come not at the expense of, or not as part of a general pot that also takes care of Mizrahi Jews. I think the final point about this disentanglement versus entanglement, and I think is that there's actually a value in keeping things entangled. And that's the value of mutual responsibility, and the idea that we are all to blame in some respect. And that is relevant when you tie 181 to 194. So your analysis is 194 analysis. That is the analysis on the compensation and the refugees. But we cannot understand, of course, 194 without the decision on partition, which is an interesting decision because, and here is maybe something that, we can develop in the future. One of your, in passing, you said that UN resolutions are not binding. And of course, technically speaking, this is correct. I wonder, however, whether UN, the General Assembly resolution are non-binding when it comes to a return of mandate. I haven't seen anything interesting about that written, but I think that maybe 181 is unique because it comes as a response to the return of a mandate taken from the League of Nations back to the UN as a general body. And I think that maybe 181 is actually of a different status, but we can develop this offline. But it's clear that 194, allowing people to return, can only make sense if you also accept 181, which means that there will be a two-state solution. Now, a host of questions comes with respect to the relationship between 194 to 181 and the current Israeli understanding that the right of return should be exercised to the Palestinian state, just like the right of return of Jews should be exercised to the Jewish state. It comes from the 181 understanding not necessarily from Felix Cohen's notion, but once we see that, and then Banna says that when we invite Mizrahi Jews back, we by definition invite them to be colonizers. Again, you know, if you accept that, then you have a problem with 181. At least if 181 would have been only under the partition plan and not whatever the land occupied under the the 48 war. But I think that if you don't see Mizrahi Jews returning as colonizers, then there's a value in seeing the entangled history, because then you say we're all in it together, and therefore we should strive to find a solution that takes care of everybody, not necessarily in the manner that Israel did that, by saying, okay, let's relegate it to the future, knowing that in the meanwhile, there's a price to pay because we discriminate against Mizrahi Jews and we discriminate against Palestinians, or I should say against Palestinians first and then Mizrahi Jews, but by saying we're all in it together, and therefore the shared responsibility component of it on all of us is there, and that's a source for a justice claim. I spoke maybe too long, so I leave it there.
I'll just try to take them quickly. So first on Leo Cohen and the kind of extra weight that I give to his career, which is wrong. I mean, Yudah has shown that this idea was in place earlier, and it came up in the first Knesset, and and the first people, according to his work, that raised it were Iraqi Jews. That said, wait a minute, you promised us something and we didn't get it, and we don't want these accounts to be set against each other because we have our own claims. So the focus on Leo Cohen is just to try to bring this discussion that is in the social sciences and history into the legal context through this kind of vocational expertise that he brings with his work on these questions that doesn't appear in the Knesset discussions. Now, with regard to the question of disentanglement versus entanglement, the bottom line is that I'm completely comfortable with saying, okay, what you're asking for is a different kind of entanglement. So I say, okay, that's fine. I want to disentangle in order to re-entangle in a different way that will create a citizenship that is not about, taking the society apart, but about integrating it in a more powerful and more compelling and in a way that is worthy of more commitment. So yes, if that's the idea, of course, and I want to connect here very quickly to an idea that I've worked on elsewhere, which is the idea of a nation of refugees. That is an American idea that is raised by John F. Kennedy and later, for example, by Hillary Clinton, that and it's interchangeable with the idea of a nation of immigrants that is maybe more familiar. This idea is about a kind of constitutional identity that derives from common displacements, whatever they are. And I have an earlier paper that I tried to propose, in which I try to propose that as a kind of identity for Israel, and so that's entirely consonant with that. I heard from Bin Badji on the earlier paper that kind of identity is really not attractive, and it's just a negative identity. We want a positive one. So, okay, I leave the question of what is the positive one open. I just want to disentangle for now. But I get your point. On the colonial question, I think I fall between Banna and yourself, maybe, in the way that I think that there's nothing essential about being Jewish, either from Europe or from the Middle East, that makes a person a colonizer. That is not the case. And Jews have a very long-standing relationship to this place, a historical relationship that really is unquestionable in my mind. However, the historical practices that Israel has chosen, starting from its founding, are very often colonial practices in the sense of inheriting much of the infrastructure that the British Mandate left after it, and kind of taking that position on as a choice, as a political choice, not as an essence. And that's what I think should be dismantled. That colonial practice. And I don't agree that the very fact of bringing people from Baghdad to Palestine is colonial. That is not the case in my view.
Thank you, Itamar. Our time is almost running off, but we have running out, but we have Rotem as the last question. Rotem, please.
Hi, so thanks, Itamar. It was really, really a fascinating paper. I have a lot of thoughts. I'll try to write you a longer email later. Right now, I want to focus on your more concrete arguments with regard to Mizrahi Jews and the way that they were influenced by this narrative. So the ramifications towards them and their position in the civic hierarchy. And you focused on ramifications that are quite practical, financial. The fact that, you know, this group, unlike many Ashkenazi Jews, did not receive financial compensation. And I think this is a very important point, but obviously it cannot account for the entire financial gap or social economic gap between Mizrahi and Ashkenazi Jews in Israel. We all know that there are many other institutionalized reasons for this. I won't get into it now because we don't have much time. But I think that for this reason, it might be a little less convincing to try to only argue for the practical ramifications. And it might make your article more convincing and more explanatory of how exactly they've acquired this position in the civic hierarchy if you also gave a little more attention to the symbolic ramifications of the Israeli narrative, which, in my opinion at least, are just tremendous. Because if I understand your article correctly, one of the main ramifications, actually, was that the Israeli government needed Mizrahi Jews to be Arabs. They needed them to be not just Jews. They couldn't just afford to be Jews, right, like Ashkenazi Jews, in order to find their place in the Israeli narrative. They had to be Arab Jews for this sort of supposed reciprocal relationship, or for this false equivalency between Palestinians and Mizrahi Jews to work. I would even consider, maybe if I were you, rather than using the term internationalization, maybe thinking of Arabization. Because I think that really what Israel was trying to do was to show that this sort of issue or conflict was a conflict that's internal to the Arab world. And for this, again, Mizrahi Jews had to be Arabs. Now, this I think it has tremendous symbolic consequences in a state where the Arab is also the so-called enemy and is also designated, right, this position as an enemy. Once Mizrahi Jews have to be confined to this position, I think this will really help show why they also acquired a sort of inferior status in the civic hierarchy in Israel. And I think this argument could help complement the sort of more practical and financial argument and make for a stronger overall thesis.
Yeah. I think that I chose this practical financial aspect very intentionally because this may or may not be related to what you described, but I think that in the last maybe decade or so, we have seen developments in this more symbolic area, whereby in terms of this, you know, when Miri Regev was the Minister of Culture and the funding decisions that she made and the kind of rhetoric that was surrounding it, and there is a real change and a positive change on the symbolic side, but it's not enough. And so I just want to focus the attention on something that was not really addressed, where I think that a lot of the symbolic issues are being addressed in some way and discussed very vehemently in some circles at this point. And with regard to the Arabization point, I think that's good. I think that's a good point. It could also be regionalization. The idea is that they're coming from Arab countries, not that they are Arabs, because really I think the motivating force behind this is what in the interwar period is called the great unmixing of populations. This is a quotation of one commentator talking about the Greek-Turkish population exchange. So the idea is that the world is mixed in a wrong way, And in order for self-determination to flourish, we need to unmix the populations and create homogeneous nation states that are much sounder and have a greater chance of success and stability. And I think this is what was the motivating kind of political imagination behind these processes. And so they're not Arab, but they are Jewish coming from Arab countries. And that allows this unmixing. That's how I see it. Thank you again.
Thank you very much. Well, I want to thank all the participants and of course to thank Itamar for this very, very interesting paper and discussion. You know, despite the fact that it's a very heavy and serious topic, it was refreshing to talk about some regular things outside the emergency and the corona. But our next meeting on Sunday at 6 o'clock in the evening will be connected to the current crisis. It will be given by Professor Gadi Barzilai, one of the principal investigators of the Minerva Center, who will talk about democracies and emergencies, no useful framework, but some are more useful than others. So it will be interesting, and I hope that we'll meet again, all of us and many more people, on Sunday at 6 o'clock. You can find this conversation, discussion, lecture also on our Facebook page. And I want to wish all of us keep safe and see you soon again. Thank you very much.
Everyone.
Thank you.